second series in the lecture series that we have commenced last week. Once again, a very hearty welcome to you, sir, and looking forward to hear from you. Thank you. Thank you so much.
Good morning, Mallikarjunaya. Good morning, Vivek. Good morning, all participants. I'm happy to be associated with you.
So 1 minute, your introduction, just an introduction of you.
Yes.
Tulya.
Is it necessary? Is it necessary?
No, not necessary. Not necessary, but sir.
For the benefit of students, it really would be. In fact, I'm sorry, sir. In fact, these introductions in my life personally and in the life of many students would inspire. The journey of your life itself would be often inspiring. So,
Very true.
Go ahead, media.
Yes, sir. To proceed, I'd request my friend Riddhi Sharma to introduce the guests to the participants. Over to you, Riddhi.
On behalf of everyone who've joined us today, I would like to welcome our guest speaker, Honourable Justice Venugopal Gowda. Our guest for today needs no introduction. Former Judge of the Karnataka High Court, Honourable Justice Venugopal Gowda enrolled as an advocate on October 26, 1979. He practiced at trial courts, appellate courts and tribunals. Sir also worked as Principal High Court Government Advocate and Special Counsel for Common Interest Test Cell and CSE cells of Government of Karnataka. He was in the panel of advocates of Karnataka Public Service Commission, Indian Railways, BDA, and various other statutory authorities and bodies. Sir was elevated as Additional Judge of Karnataka High Court on July 4, 2007, and became the permanent judge on April 17, 2009. Sir retired on 15th June 2017 on attaining the age of superannuation. We welcome you, sir.
Thank you, Ma. Thank you. Thank you for the introduction. Thank you, everybody, for giving me this opportunity. We are on a very important subject in civil litigation is concerned. I'll not be touching the appeals under the criminal jurisdiction. I'll be touching the aspect of appeals in the civil jurisdiction is concerned. Now, as you all know, the trial judge is the kingpin of the system. He directly comes in contact with the litigant. He observes the plight of the litigant. He tries to analyze what the problem that is sought to be posed before him, because everything commences from the trial only. Now, to move to an appeal, there has to be what is called either an order or a judgment or a decree. These three things are very essential. And as far as judgment is concerned, you will find the definition under section 2, subsection 9 of CPC, what is meant by a judgment. Then, as far as definition of an order is concerned, you will find it under section 2, subsection 14. And as far as a decree is concerned, it is again subsection 2 of section 2 CPC. Unless these three are there, there cannot be any appeal at all. One of these things should be there. Either to prefer an appeal under section 96 to 109, or under order 43, or otherwise under section 107 CPC, 104 CPC is concerned. Now, why this appeals is the question. In the judicial system, appeals occupy a very important position. The reason is a dissatisfied litigant. In a litigation, all of you know, there will be at least two parties. One is bound to succeed, another is bound to lose. The losing party may entertain many doubts. He may not be aware of why he has lost it, or the judgment which has been rendered by the court may not have that much clarity also. It may not be in a manner which everybody can understand also. If such a judgment is is delivered, and he feels aggrieved by it, then he should have recourse to seek justice, or at least an affirmation whether what has been done is right or not. So this is why the hierarchy of our judicial system has provided for either an appeal. If no appeal lies, at least a revision is available. An appeal is available. If wherever there is no appeal, at least a revision is certainly available. If these two are not there, then we have what is called as 226 writ powers, which everybody under the sky can avail, provided certain things are satisfied, which we need not have to bother about. Now, why this appeals also, why there is a need for appeals is many a times it is fallibility of the judge. I am yet to come across a judge whose order has not been appealed against. Every judge has, one way or the other, might have committed something wrong. Some error, instead of calling it as wrong, some error he must have committed while delivering the judgment or order, as the case may be. And that may lead to an appeal. Now, on this aspect, I would cite you a judgment of the Supreme Court in the case of KP Tiwari versus State of MP, which is reported in 1994, Supplement 1, Supreme Court Cases 540. Relevant paragraph is para 4, part of para 4. It says, this is what the Supreme Court has said. I can't say anything better than what the Supreme Court itself has said. That's why I'm bringing to your notice this judgment. Their lordships have said, our legal system acknowledges the fallibility of judges and hence provides for appeals and revisions. Supreme Court acknowledges the fallibility of judges and system having provided for appeals and revisions. Then a judge tries to discharge his duties to the best of his capacity. Everybody may not be biased or prejudiced, or may not be a dull-headed goose, may not be a black sheep or something. But there may be honest people also, but honest people do commit mistakes. That's why there is nobody on the earth so far I have come across who has not committed a mistake or has not committed an error. A judge, this is what this is, Supreme Court, a judge tries to discharge his duties to the best of his capacity. While doing so, sometimes he is likely to hear pressure of work, the environment in which he will be conducting himself, several factors, it is less said. Sometimes we used to say on a lighter note, he is not seem to be in good mood. Many a times when we were practicing, we used to say, oh, the judge appears to be, something must have gone wrong at home or on the way to court or in the precincts where he must have been sitting or something must have gone wrong. That's why he is not able to focus himself on what we are trying to bring into his notice. This is what the Supreme Court says. While doing so, sometimes he is likely to hear. It is well said that a judge who has not committed an error is yet to be born. Supreme Court itself says he is yet to be born. No such person is there. On a lighter side, I will say, I had seen one judge in the High Court whose judgments were tumbled like anything. The reason is, at least if his judgments will not be less than about 40 to 50 pages, even if it is required, may not be required to be more than 4 to 5 pages, but he used to write such lengthy judgments. One such judgment of him was taken up by me in Supreme Court while I was practicing. It ran to about 3.5 pages. And one sentence itself to more than a page, one sentence. Then it was before a division bench. One judge was not inclined to entertain the SLP. The other judge said, no, there is something wrong. You go to so-and-so page, read that sentence. I'm not able to follow what transpired in the mind of the judge to arrive at that conclusion. He said, I can find out in that very sentence, both past tense as well as present tense also. Let us forget regarding present tense, future tense also you will find it, he said. I am not able to understand. Then the other judge turned to that relevant page. He also said, yes, you take out a notice of remand. We will see what to be done. That is how the judges, while writing, unless the judgment is crisp, only to the required extent, then they do commit mistakes while pronouncing the judgment is concerned. This is what it says. He is yet to be born. And that applies to judges at all levels, including the Supreme Court, they say, at all levels, from the lowest to the highest. Sometimes the difference in views of the higher and the lower courts is purely a result of a difference in approach and perception. On such occasions, the lower courts are not necessarily wrong and the higher courts always right. It has to be remembered that the lower judicial officers mostly work under a charged atmosphere and are constantly under psychological pressure, with all the contestants and their lawyers almost beating down their necks, more correctly up to their nostrils. This is the plight of a person who works at the lowest of the rank. If you join as a munsif, or now it is called as junior civil judge, the workload is that of a donkey. If you go a little higher, your load gets reduced. You become a horse. If you go a little further, you become a racehorse. Like that. The workload is so much on the trial judge. See, if I sit as a single judge in the High Court, my workload was so much every day, at least about 100 matters, I have to get it listed and attend to it. When I sat in the division bench, it's about 30 to 40 matters, not even half of it. Whereas if you go still higher up, which opportunity I did not get, I can say that their workload is much smaller than what the division bench here is. One single judge before whom I used to appear, his lordship used to turn out at least about 100 to 150 matters per day. When he moved to the division bench, I could see him almost relaxing himself. And I asked him personally, sir, you are turning out so much work then and now it is. Mr. Gowda, at that time, there was not much I can say. I was laying down precedent law. Now, whatever I say becomes a precedent for the single judges are concerned. So I have to apply myself. I have to spend my time, think over, ponder over the issues presented before me, then come to a correct conclusion. Then his lordship went to the Supreme Court, retired as a Chief Justice of India, and now he is the Human Rights Commission Chairman. This is H.L. Dattu. To be honest with you, I'm naming the person also. This is how the workload also matters. The environment also matters. The kind of assistance the lawyer gets from the bar also matters. You may not be aware. Some of the lawyers say, Your Lordship, Your Honor may take it as heard, and they walk away. What this fellow should do, the judge, before whom such a statement is made, he is not getting any assistance. And he can't take that person head on because in his court, suppose he is working in a rural place. Every day that same fellow would come. The lawyer would come before you. So he can't entangle with him. He can't open up. That's why most of the trial judges, they don't interact at all with the members of the bar. They simply listen whatever you say. They write whatever they wanted to write. So that assistance will be lacking. The workload is so much. All these factors lead to the person committing inadvertent errors. Nobody would commit errors wantonly. Nobody would expect his order to be interfered with by any court for that matter. I was also not pleased when my orders were set aside because I have put in my labor. I have done my best. But still, if something has gone wrong, because there is a change of law. There is a perception change, which I was not able to know at the point of time when I decided the matter. Otherwise, I don't want any of my orders to be interfered with. When I was sitting as a judge, having taken the oath that I will discharge my duties to the best of my ability, my conscience, then I will certainly not go wrong. But still, there may be a human error. That human errors require to be rectified. And that's the reason why the hierarchy in the system has provided for the appeals. With this, I'll take you to one more judgment, which is equally important. That is reported in, this is a very important judgment on the aspect of appellate jurisdiction or infallibility of the judges is concerned. It is reported in 1998 volume 5 SEC 513. The relevant paragraphs are 23, 25, 26, and more relevant among them is 27. That is in the case of Ashok Transport Agency versus Avdesh Kumar. Here I tell you, a certain judge had taken a certain view while deciding an earlier case. Later on, that view was taken up before the Supreme Court. It was by the Calcutta High Court, which had decided the matter. The view of that court was not accepted, it was set aside. But when a subsequent case came up, the very same judge said, I'll stick to my view irrespective of what the Supreme Court has said. Supreme Court did not approve what view he had taken. And still he was sticking to his view, thinking that he is always right. That was not taken kindly by the Supreme Court. They interfered and they castigated the learned judges concerned. Here you will find paras 23, 25 onwards. It says, not Avdesh Kumar, sorry. State of West Bengal versus Shivanand Pathak. Sorry. State of West Bengal versus Shivanand Pathak. 1998 5 SEC 513. Para 25, it says 23. All judicial functionaries have necessarily to have an unflinching character to decide a case with an unbiased mind. Judicial proceedings are held in open court to ensure transparency. Access to judicial record by way of inspection by the litigant or his lawyer and the facility of providing certified copies of that record are factors which not only ensure transparency but also instill and inspire confidence in the impartiality of the court proceedings. 24. Unlike suits, proceedings under Article 226 of the Constitution are not conducted strictly according to the provisions contained in the Code of Civil Procedure, but are held in accordance with the procedure devised by the High Court itself, under which a fair hearing is provided to the parties concerned before a decision is rendered. In other words, principles of natural justice. Then 25. Bias may be defined as a preconceived opinion or a predisposition or predetermination to decide a case or an issue in a particular manner, so much so that such predisposition does not leave the mind open to conviction. It is, in fact, a condition of mind which sways judgments and renders the judge unable to exercise impartiality in a particular case. Bias has many forms. It may be pecuniary bias, personal bias, bias as subject matter of dispute, or policy bias, etc. In the instant case, we are not concerned with any of these forms of bias. Kindly see here. We may have to deal with, as we shall presently see, a new form of bias, namely bias on account of judicial obstinacy, means committed to a certain philosophy is concerned. Now here it says, this is very important, para 27. Judges, unfortunately, are not infallible. Judges, unfortunately, are not infallible. As human beings, they can commit mistakes, even in the best of their judgments, reflective of their hard labor, impartial things, and objective assessment of the problem put before them. They all do definitely a good work. A lot of homework is done before coming to the court. They just read the papers. But when you read the papers and come to the court, you should have an open mind. If you close your mind there itself, then it will be empty formality of hearing the lawyer. That should not happen. Lawyer should always be allowed to have his say, full say. Then you will get the best out of the lawyer, you will be in a position. You have to read the papers only to know what is the substratum of the dispute is. Why the person feels aggrieved and he has come before you. Keep that in mind. Allow the lawyers on both sides to present their respective cases. Once that happens, then you will know where there is injustice. Sometimes there may be injustice, but law does not allow you to correct it. You are bound to fall in line with law. You don't have one judge who would not have the freedom of deciding according to what he feels right. Judge has to decide the case in accordance with law only. Justice must be rendered in accordance with law, not otherwise. He is not sitting as a mediator. He is not sitting, even an arbitrator cannot do that because arbitrator has to apply law and decide it. Whereas a mediator or a conciliator, they can say, yes, law is there, but we are concerned. We only wanted to do justice. According to us, injustice had happened here. So that's why we try to remedy the injustice in this particular manner of bargaining, hard bargaining. But as far as judges are concerned, they don't, though they are empowered to decide matters, they have to decide matters in accordance with law only. Then this is what their lordship say. In the judges, unfortunately, are not infallible. As human beings, they can commit mistakes even in best of their judgments, reflective of their hard labor, impartial things, and objective assessment of problems put before them. In the matter of interpretation of statutory provisions or while assessing the evidence in a particular case or deciding questions or facts, mistakes may be committed bona fide, which are corrected at the appellate stage. This explains the philosophy behind the hierarchy of courts. Such a mistake can be committed even by a judge of the High Court, which are corrected in the letter patents appeal, if available, or by the Supreme Court. Now, if a correction has been done and whatever view I had has not been accepted, then I am bound to fall in line with whatever is the corrected version is concerned. What has appealed to the higher court should be my pathway or should be my guideline. What I thought was right, having not been accepted by a higher forum, then I should not go by the same path which I had chosen. I have to go by the path which has been laid out to me by the higher forum is concerned. That is what Article 141 of the Constitution mandates. Now, with this, I'll take you to another. What is the significance of an appeal? Why an appeal is required? As law students, all of you, I would request to read this judgment in full when you get time. That is Tirupati Balaji Developers versus State of Bihar, reported in 2004, Volume 5 SCC, page 1. Here, under the caption, they pose a question to themselves. It's an interesting case. I will not go into the details little later, otherwise you will lose interest. I want you people to read the judgment in full. Then there will be a very meaningful interaction when we get an opportunity. Para 13, what is the significance of creating an appellate forum? What is the significance of creating an appellate forum? That is the question mark. And what is sought to be achieved by creation of such hierarchy in the justice administration system? These are the two questions posed by the court to itself, and answers are given later. I'll read again. What is the significance of creating an appellate forum? And two, what is sought to be achieved by creation of such hierarchy in the justice administration system? Their lordships quote from a book called Judges on Trial, and this is what has been said. The appellate court plays an important role in securing high standards of judicial behavior in court. Bearing this in mind, the role of the Court of an Appeal in checking judges should not be underestimated. The Court of Appeal regards itself as fulfilling a disciplinary function. The Court of Appeal carefully phrases its criticism. The court usually makes clear that they do not doubt that the judges are actuated by best motives, or that in strong desire to do justice, a judge may make mistakes. But they use the language clear enough to ensure that the judges to perform criticism is addressed, as well as other judges get their message. So this is nothing but disciplining the system itself, not a particular judge. So for that, this is what has been said. Their lordships further elaborate and say, the role of the Court of Appeal in checking judicial conduct and in securing high standards of judicial behavior is in a court is manifold. The Court of Appeal censures and criticizes judicial misconduct in particular cases and corrects injustices resulting from such misconduct. Whether it reverses the judgment, quashes the conviction, reduces the sentence, or changes the judgment in any manner, the disapproval and condemnation of the misconduct restores the public confidence in the courts, which might otherwise have been impaired. The party offended or prejudiced, and the public at large might be tempted to attribute misconduct of a particular judge to the judiciary as a whole. The disapproval and criticism of the appellate court, even without amending the judgment, eliminates such danger and restores the scales of justice to their proper balance. For the system to repose confidence, there has to be an appeal for correction. If suppose a higher forum or men with wisdom and better learning say that what has been done is right, then the litigant, howsoever unhappy he may be with the original judgment or order is concerned, he has to feel satisfied and he has to accept it. Now, you would recollect in the recent past one unfortunate incident which triggered a lot of debate and which appeared in the press as well as electronic media, that of Mr. Prashant Bhushan's case. It generated so much discussion in the media, both electronic as well as the social media. There, he was found guilty and has been punished, of course, with a lighter punishment that we are not on the merit or otherwise of the matter. His cry was that there is no appeal. Whatever you say cannot be the last word. I should have an appellate forum. That was not recognized by the bench which delivered the order, first order as well as second order. Later on, in another case wherein he is facing contempt, that argument found acceptance by a bench of 5 judges. And now a question has been formulated, a bench of 3 judges. A question has been formulated and it has been now referred to a 5-judge bench is concerned. So an appeal ensures that even an aggrieved mind would feel consoled in case a larger bench or a higher forum affirms the finding of the original forum. So that's the reason why in the hierarchy, suppose you take now the junior division judges are concerned in the civil side I am referring to. Any person who completes his education in the law school, enrolls himself, can take the examination as far as the junior division judges post is concerned. But for a senior division, there is no direct recruitment. A person has to put in a certain number of years. There is no prescribed as such, but it goes by seniority cum merit. Then, by then, as a junior division judge, he must have spent not less than about 7 to 8 years to get into the next level is concerned. But for a district judge, there is direct recruitment as well as promotion. To become a promoted district judge, one has to spend at least about 14 to 15 years of service in judiciary. By then he would have matured himself because of a lot of tribulations which he has undergone and the education which he must have received from all sources, from the courts as well as litigant as well as the lawyers community is concerned. For a direct recruit is concerned, he must have necessarily be a practicing lawyer. He must be a practicing lawyer having completed 7 years of practice. So having put in 7 years of practice in the courts, he must have seen what the world is, what the society is, what are the problems which the society and men and material are having. That must have definitely made him a man of wisdom. So his experience gives him that edge of taking the examination. Suppose he completes the examination, clears the vivos, and finds his name in the merit list, he gets into the district judge post because he has remained as a practitioner for 7 years. Even a junior division officer who moved into the slot of junior division officer, civil judge is concerned from law school directly after enrollment, to become a senior civil judge, he must have to spend, not necessarily according to me, 7 to 8 years. 7 to 8 years, then again 7 to 8 years in the senior division post, about 14 to 15 years only he can think of becoming a district judge is concerned. So much nurturing will be there. So much training will be undergone, and that makes him to become the appellate judge is concerned. Now this junior division is concerned, they don't decide any appeals. They only decide original matters. Senior division officers, civil judges are concerned, they decide the original appeals, original matters as well as appeals also. District judges, again, they have original side as well as appellate side also. Whereas High Court, other than writ side, everything is appeals only, be it civil or criminal as the case may be. Now, this is how a person who has undergone a certain number of years of training, though sitting as a judge, every day is a training period for a judge. Every case gives him a trial. We are conducting trial before him, but a judge is on trial every day in every case. He is watched by hundreds of eyes. He is talked about by hundreds of mouths. He is whispered in hundreds of ears. That's why a judge is always on trial. With all that, unknowingly, some error may be committed, and that requires correction. Now here, in the beginning, I was just telling you people how this precedent law also makes a judge to commit mistakes. What Article 141 says, law made by the Supreme Court is binding on all the courts as well as the authorities are concerned. Similarly, whatever law is made by the high courts or the trial courts in the state are bound by it. If some judgment is delivered by the high court and that is brought to the notice of a trial judge, he is bound to apply it. Suppose that judgment is applied and the case is decided. Later on, the judgment which has been applied is overturned elsewhere. And by then, the other side takes up the matter in appeal. This judgment is bound to be set aside. It is not because of the judge's mistake. It is because the system itself has made him to commit the mistake. So to prevent such things, an appeal is provided. And now we will get into what the substantive law is. Now, here you will find appeals of 3 types, that is, appeals of at least 2 types, that is, appeals against decrees and appeals against the orders are concerned. I read the note which has been prepared by the 2 students. They have done a wonderful work. I should appreciate the effort put in by both students are concerned to prepare that note. Everything has been well covered. I am only touching and leaving the matters at this stage because of the lack of time. Here, sections 96 to 99A of CPC are appeals from original decrees are concerned. Then sections 100 to 103, appeals from appellate decrees, that is, second appeals are concerned. Then sections 104 to 106, appeals from the orders, means not decrees, but orders. Suppose somebody wants to prefer an appeal against an order, he can't invoke 96 or 100, he can only invoke 104 is concerned. Then powers of the appellate court, be it against the decrees or the orders, it is 107 only. Section 107. Then procedure in appeals from appellate decrees and orders, you will find it in section 108 CPC. Then 109, section 109 is appeals to Supreme Court. Now virtually in the present day circumstance, that has lost its importance. No High Court is granting certificate to take up the matter in appeal to the Supreme Court, because in every field of law, Supreme Court has laid down what the ratio of law concerning the subjects are concerned. That's why normally they are applied under cases decided by the High Courts. And against single judges orders, there cannot be any certificate appeal. It is only division benches. So you can expect a good judgment having been delivered by the division bench following the Supreme Court precedents. And that's why now everybody try to prefer special leave petitions under section 136 instead of seeking a certificate under section 109 CPC, which would normally be refused. So 109, though is there in statute book, has not been of much importance in the present day world is concerned. Then procedures are, this is substantive provisions or whatever we saw. Then procedures, you will find the provisions under Order 41 relatable to section 96 to 199A CPC are concerned. Then the provisions under Order 42 being appeals from appellate decrees. Then Order 43, the procedure with regard to appeals from the orders. Then Order 44, appeals by indigent persons, that is the procedure there. Then 45, appeals to the Supreme Court, that is the procedure in respect of the provisions contained, which I referred to earlier. Now, before going into several aspects, I would bring to your notice one important judgment of the Supreme Court rendered recently by a judge who has gone from the Karnataka High Court by His Lordship Justice Abdul Nazir, sitting with His Lordship Justice Sanjeev Khanna, in a judgment reported in 2020, Volume 4 SEC 313. It is with regard to the subject appeals, what we are discussing today. What is the meaning of an appeal? How an appeal should be considered? All that has been laid down here under the title Malluru Mallappa versus Kurvantappa. Their lordships say the expression appeal, as all of us know, has not been defined in CPC. You don't find a definition in CPC with regard to what an appeal is or what a suit is. It is, according to the Supreme Court, it is a judicial examination of the decision by a higher court of the decision of a it is judicial examination of a decision by a higher court of the decision of a subordinate court to rectify any possible error in the order under appeal. So meaning thereby what started as a suit, that very record gets transmitted to the appellate court. The appellate court considers the very record of the suit and then decides the matter. It is the judicial examination. According to the Supreme Court, it is examining the decision of the court below, whether there is any error, and if possible, whether that can be rectified. Then the law provides the remedy of an appeal because of the recognition that those manning the judicial tires to commit errors. So as latest as this judgment is in February. So February 20 also, the Supreme Court still continues to recognize the fact that there could be judicial errors, judges might have committed errors, and that requires to be corrected. Law provides the remedy of an appeal because of the recognition that those manning the judicial tires to commit errors. A right of appeal carries with it a right of rehearing on law as well as on fact. So the whole case is open for consideration before the appellate court is concerned. A right of appeal carries with it a right of rehearing on law as well as on fact, unless the statute conferring a right of appeal limits the hearing in some way, as has been done in the second appeal arising under CPC. So for an appeal, that is the first appeal, what we call under section 96 is concerned, the whole case is open for reconsideration, rehearing. Virtually it is a rehearing by a higher judge or higher positioned judge is concerned or higher tier judge is concerned. Whereas second appeals is concerned, it is only a substantive question of law, which we'll consider it later. Then the Supreme Court moves further and says, the essential criteria of appellate jurisdiction is that it revises and corrects the proceedings in a cause already instituted and does not create that cause, meaning thereby it is not a new case that is being judged, it is the existing or the case instituted earlier that is being taken up for consideration. The appellate jurisdiction may be exercised in a variety of forms, in a variety of forms, and indeed in any form in which the legislature may choose to prescribe. An appeal is a process of civil law origin and removes a cause entirely subjecting the fact as well as the law to review and retrial. Means a case tried and decided by a lower court is taken up for reconsideration by the court of superior jurisdiction invested with the power, and that court decides the matter with reference to the existing record only, because the suit is the appeal is nothing but a continuation of the suit itself. Then it is said, it is settled position of law that an appeal is a continuation of the proceedings of the original court. Ordinarily, the appellate jurisdiction involves a rehearing on law as well as on fact and is invoked by an aggrieved person. The first appeal is a valuable right of the appellant, and therein all questions of fact and law decided by the trial court are open for reconsideration. Therefore, the first appellate court is required to address itself to all the issues and decide a case by giving reasons. It is not certification, it is reconsideration and redelivering the judgment itself. The court of first appeal must record its findings only after dealing with all issues of law as well as fact, with the evidence, oral as well as documentary, led by the parties. The judgment of the first appellate court must display conscious application of mind and record findings supported by reasons on all issues and contentions. So contentions have to be taken note of, points have to be formulated, then the same should be analyzed, that is with reference to the oral and documentary evidence and judgment rendered. That is what is prescribed under Rule 31 of Order 41 CPC is concerned. Then their lordships note, a first appeal under section 96 is entirely different from a second appeal under section 100. So the difference between the two is pointed out. First appeal is entirely different from a second appeal under section 100. Section 100 expressly bars second appeal unless a question of law is involved in a case and the question of law so involved is a substantial in nature. A very case may involve a question of law, but for an appeal to be preferred and pursued under section 100 CPC, it should involve a substantial question of law. And what is meant by a substantial question of law, I'll take you a little later. Then their lordships analyze the mandate which is required to be applied by the appellate court in terms of Order 41, as indicated in order under Rule 31 there, meaning thereby the appellate court should state the points for determination, decision thereon, reasons for the decision, and where the decree appeal from is reversed or varied, the relief to which the appellant is entitled to, that is A, B, C, D, have been enlisted therein. Then the lordships move further and say, the appellate court has jurisdiction to reverse or affirm the findings of the trial court. The first appeal is a very valuable right of the parties, unless restricted by law. The whole case therein is open for rehearing both on questions of fact and law. The judgment of the appellate court must therefore reflect its conscious application of mind and record findings supported by reasons on all the issues arising with the contentions put forth and pressed by the parties for decision of the appellate court. Sitting as a court of first appeal, it is the duty of the High Court to deal with the issues and the evidence led by the parties before recording its findings. The first appeal is a valuable right, and the parties have a right to be heard both on questions of law and facts, and the judgment in the first appeal must address itself to all issues of law and fact and decide it by giving reasons in support of the findings. That is what has been said. For laying down this law, number of precedents have been cited, and that is the reason why the appellate court discharges a much higher duty. Now, as far as a trial judge is concerned, he has to formulate the issues after once the stage of the pleadings is complete, that is order 7, the plaint, order 8, written statement, then the supplementary issues, if any. Once that is complete, then the examination of the parties under order 10. Then once that examination is complete, thereafter interrogatories under order 11. Suppose a judgment can be rendered on admissions with reference to rule 6 of order 12, that can be done. Once that stage is over, then you will find order 14, wherein the court is obliged to frame issues with reference to the material pleadings of the parties are concerned. Once pleadings are complete, once the issues are casted, then the parties are enabled to file affidavit evidence under order 18. Once order 18 stage is complete, that is examination consideration is over, then the judgment is delivered under order 20 CPC. Once this stage is over, then once order 20 is crossed, then comes the appellate forum. That is section 96 onwards, that stage comes. Then you have, this is what is regular appeals against the decrees are concerned, what we saw, that is order 41. Order 47. Now, these appeals from orders are concerned. You will find under order 43, rule 1, certain orders against which an appeal could be preferred. Because there is no decree, only an order is there, and only against those specified category of cases or orders, appeals can be preferred. There can be miscellaneous first appeal, there can be miscellaneous second appeal also. Now, miscellaneous first appeal is available as a matter of course, whereas miscellaneous second appeal is concerned, it is again on substantive questions of law. Now, where is this miscellaneous question, second appeal arises? Normally, when the appellate court, instead of passing a decree, passes an order. The final decision of the appellate court, once it does not qualify itself into a decree, it remains in the stage of an order. Such an order can be questioned in a second appeal or a miscellaneous second appeal. If you ask me an example, suppose the appellate court before which an appeal under section 96 is preferred, while deciding the matter, finds that it is a case where a remand is called for, or it passes an order where additional evidence is required to be recorded. Such a question can be questioned in a miscellaneous second appeal by invoking the provision under section 104 CPC is concerned, and that becomes a miscellaneous second appeal, and whatever is decided therein applies not only to the trial court but also to the first appellate court is concerned. So these are the kind of appeals that are available to a litigant under the provisions of civil procedure code is concerned. Same thing may be available in many of the local statutes or the statutes made by the state concerned. This is with reference to the procedure prescribed by the union government is concerned. Now, as far as the state enactments are concerned, you will find number of state enactments providing for appeals, and that can be to the authorities themselves or to the courts as the case may be. Say, for example, Workmen Compensation Commission. Now, the appeal, the original proceeding is decided by a labor officer. Earlier, the appeal, earlier also the appeal was to the High Court only as a miscellaneous first appeal, depending upon the pecuniary limits are concerned, either to a single judge or to a division bench, as the case may be. Now, the labor commissioners have been taken out. The workman compensation claims can be filed before the civil judge junior division is concerned. I believe it must be a senior division, not junior division. Senior division. Once the civil judge junior division decides the matter, then an appeal can be preferred before the High Court, either before the single judge or the division bench, depending upon the pecuniary limits are concerned. Same thing, you can find it under the Motor Vehicles Act also. The motor vehicle claims, accident claims are decided either by the senior division officer or the district judge, as the case may be. Then an appeal is provided to the High Court. So like that, the statutes also provide for appeals. Now, what is meant by a substantive question of law or substantial question of law became the subject matter of consideration in a case called State Bank of India versus S.N. Goyal, reported in 2008, volume 8 SCC, page 92. At para 13, relevant page 103, under the heading, what is a substantial question of law? This case is decided by His Lordship Justice Ravindran R.V., whose judgments you will find it to be most reasoned judgments. Under civil law, in the recent past, I can say he is an authority as far as the civil law judgments are concerned. Any judgment you take it, you will have elaborate discussion. So it's wonderful to read any judgments rendered by His Lordship on civil law, including arbitration law. If you get an opportunity, please keep reading the judgments of Justice Ravindran to know or to have better insight into the intricacies of law or fact are concerned. Now here, what is said on the substantial question of law is of importance. Kindly permit me to read it. It says, second appeal would lie in cases which involve substantial question of law. The word substantial prefixed to question of law does not refer to the stakes involved in the case, nor intended to refer only to the questions of law of general importance. It is not the stakes nor questions of general importance, but refers to impact or effect of questions of law on the decision in the list between the parties. Substantial questions of law means not only substantial questions of law of general importance, but also substantial questions of law arising in a case between the parties. In the context of Section 100 CPC, any question of law which affects the final decision in a case is a substantial question of law as between the parties. A question of law which arises incidentally or collaterally, having no bearing on the final outcome, will not be a substantial question of law. Where there is a clear and settled enunciation on a question of law by this court or by the High Court concerned, it cannot be said that the question involves a substantial question of law. It is said that a substantial question of law arises when a question of law which is not finally decided by this court, meaning there by the Supreme Court or by the High Court concerned, so far as the state is concerned, arises for consideration in the case. But this statement has to be understood in the correct perspective. Where there is a clear enunciation of law and the lower court has followed or rightly applied such clear enunciation of law, obviously the case will not be considered as giving rise to a substantial question of law, even if the question of law may be one of general importance. On the other hand, see this, on the other hand, if there is a clear enunciation of law by the High Court, by the Supreme Court or the High Court concerned, but the lower court had ignored or misinterpreted or misapplied the same, the correct position of law as declared or enunciated by this court, that is the Supreme Court or the High Court concerned, would have led to a different decision. The appeal would involve a substantial question of law as between the parties. So not correctly applying the precedent would amount to a substantial question of law. not correctly understanding, not correctly applying the precedent to the case when decided by either the original court or the appellate court, that would lead to a substantial question of law falling under section 100 CPC is concerned. So that's how the substantial questions are to be framed. In the appeal itself, memorandum of appeal should have separate heading, substantial questions of law. And what the lawyers prepares as substantial question of law is not the law. Ultimately, the judge has got the duty to formulate substantial question of law on his own. Unless a substantial question of law is involved, even a notice in second appeal cannot be ordered. Admission, if a second appeal is admitted, then substantial question of law has to be formulated first. With reference to that question, the appeal has to be admitted and notice ordered. Now, you find number of judges, number of courts ordering notice in a second appeal without formulating a substantial question of law, which is not the correct position. Supreme Court has pointed out time and again, but that is not being applied. And I'm sorry, that should not be the procedure. For a second appeal to be entertained, a substantial question of law has to be formulated and notice ordered, or admission ordered and followed by notice. And once the respondent appears, he has every right to point out that what has been formulated as a substantial question of law is not the substantial question, because I was not heard when you formulated the question. He has every right to say what was decided behind me or before ordering notice to me can never be the finality. You reconsider that substantial question of law because you have not been appraised of a certain position. And this is the position. That is why there being no substantial question of law, dissolve that question, dismiss the appeal, not falling under section 100 CPC is concerned. Suppose upon hearing or at the time of hearing the appeals, the appeal having been admitted on a certain substantial question of law, other additional substantial questions of law do arise for consideration. Subsection 5 of section 100 enables the court to formulate additional substantial questions of law. Once that is done, then there is a need to hear the lawyers on both sides, and that aspect of the matter is concerned. Hearing in second appeal, that is while exercising jurisdiction under section 100 is concerned, it can be only on substantial questions of law and not on facts. On facts is concerned, section 96 is quite wide open. It is an ocean. If you have the men and material, you can be at your best before an appellate court, because there, see, practicing on a trial side is really a skill. But practicing on the appellate side, it not only requires skill, but intelligence also. You have to be learned. You have to be a voracious reader. Before the trial court, you can find number of lawyers are not that much skilled, not that much well-read, but they are skilled. They somehow bring the parties to a certain stage and try to get a lot of things, because in pleadings, many a times, particularly rural pleadings, now we are in a city, we do not know the pitfalls of the rural side litigant is concerned. Rural side litigant, when he comes to a lawyer's office, he will only have one or two words to say that this is the injustice done to me. Rest of the case is all prepared by the lawyer only. And when the witness comes to the witness box, or the litigant comes to the witness box, if the other side lawyer is a skillful lawyer, he knows the art of eliciting the truth from the person. He will be completely exposed there. That shows the case is not what the litigant projected before the lawyer who instituted the suit, but it is nothing but a lawyer's brief itself. If the lawyer had the time to spend with the litigant, elicit all the things at the stage of filing itself, number of cases will end up in the trial court itself. You don't find such category of lawyers, which we used to see earlier. Now things might have changed. I believe we keep improving. We should improve rather. Whether we are improving or not is a question mark. But every day we should improve upon ourselves. I should be better than what I was yesterday. That should be the attitude of every human being. I should do better than what I did yesterday. Better means not better for myself, better for the environment in which I live, better for all those with whom I mingle every day. I should be an asset to everybody. That unless that goodwill is generated, then we lack human qualities. A true human being is one who not only cares for himself, but also cares for all fellow beings. Fellow beings means the society as such. Now, in the litigation world, you see less such people. It's more of a cunning attitude. One trying to outscore the other by either non-disclosure or suppression or something of that nature. True disclosures do not happen in many cases. Only a skillful judge or a judge who interacts with the lawyers, who doesn't simply keep listening and taking a decision ultimately. See, I was sitting with one senior judge who had in fact recommended me while he was in the collegium. He was a part of the collegium which recommended my name. When I got the opportunity to sit with him, I had watched him as a district judge. Then he had gone to the High Court and became the collegium member. On the first day itself, he said, Venugopal Gaudre, ನಾನು ಯಾರ ಹತ್ರನೂ ಏನು ಪ್ರಶ್ನೆ ಕೇಳಲ್ಲ, ತಾವು ಏನಾದರೂ ಕೇಳೋದಿದ್ರೆ ಕೇಳ್ಕೊಳ್ಳಿ, ಆದರೆ ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳಿ, ಕ್ವಶನ್ ಕೇಳಿದಾಗ ಒಂದೊಂದ್ಸಾರಿ ಮೇಲ್ಗಡೆನೂ ಬೀಳ್ತಾರೆ ಲಾಯರ್ಸು, ಅದನ್ನು ಹ್ಯಾಂಡಲ್ ಮಾಡೋ ಕೆಪಾಸಿಟಿ ಡೆವಲಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅನ್ನೋದು ಜ್ಞಾಪಕ ಇಟ್ಕೊಳ್ಳಿ. You do whatever you want. He was very frank enough. And I had watched him. He was always, see, those who come from the service cadre are concerned, they are less interactive because they are come up in that training, in that field only. They normally the trial judges do not open up. Whereas those who come from the bar is concerned, they try to put a thing in a very brief form, try to analyze things at the earliest and try to render justice, because that's why 2/3 is from the bar and 1/3 is only from the service category. Rightly so. Maybe there are good people also from service side. There are equally bad people also from bar side also. It is not as if, but that is the society. Then I was interacting on the first day itself when I sat with him. By then I had put in about 6 months on the bench. And I asked certain things. He said, "Parvailri, ನೀವು ಚೆನ್ನಾಗಿ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತೀರಿ." When we were going from the court in the lunch session, "Parvailri, ನೀವು ಚೆನ್ನಾಗಿ ಹ್ಯಾಂಡಲ್ ಮಾಡ್ತೀರಿ, ಇಲ್ಲಾಂದ್ರೆ ಅವ್ನು ದಿವಸ ಎಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತಾ ಕೂತಿರೋನು." I had some hesitation, to be honest with you people. I had some hesitation. I said, "Sir, this is the advantage. ನಮ್ಮ ಬಗ್ಗೆ ನಾವು ಆ ಕಡೆ ಇದ್ದಾಗ ಇವ್ರೇನು ಕೇಳೋದೇ ಇಲ್ಲ, ಏನು ಇವ್ರಿಗೆ ಅರ್ಥ ಆಯ್ತಾ ಇಲ್ಲ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ ಅಂತ ಮಾತಾಡ್ಕೊಳ್ತಾ ಇದ್ವಿ. ಈಗ ನಾನು ತಮ್ಮ ಜೊತೆಲಿ ಕೂತ್ಕೊಳ್ತಾ ಇರೋದನ್ನ ಫ್ರಾಂಕ್ ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಸರ್. ಹೌದೇನ್ರಿ, ನನ್ಗೆ ಯಾರು ಈ ಮಾತು ಹೇಳೇ ಇಲ್ವಾ? ಇಷ್ಟು ದಿವಸ ನನ್ನ ಜೊತೆ ಇಷ್ಟು ಜನ ನಿಮ್ಮ ಬ್ರದರ್ಸ್ ಎಲ್ಲ ಕೂತಿದ್ರು, ಹೇಳೋದು ಗೊತ್ತಿಲ್ಲ ಸರ್, ನನಗೆ ಹೇಳಬೇಕು ಅನ್ಸ್ತು, ಹೇಳ್ಬಿಟ್ಟೆ ಸರ್. Don't worry, this is how the frank discussion should take place. But I have put in about 12 years in the district judiciary, came here for about 10 years back. 22 years I have spent here. Now I'm in the fag end. He was almost about a month left then. He said, "I am the fag end. Now it may not serve any purpose. You have opened up my eyes and ears. I should have interacted. I should have been well informed by the bar is concerned if I had interacted." That's how things happen. So interactions give the judges a lot of inputs. You can know where the truth lies. Suppose something is not clear to you, you yourself is in dark and you are deciding the fate of the litigants, then see the kind of injustice that will happen. That should never happen. You should be well informed. You should have a clear thought about the process is concerned, you should arrive at a just conclusion in accordance with law. Then only you should pronounce upon, because whatever is decided in the High Court normally becomes a precedent for the lower courts are concerned. If I have not interacted, I have not elicited, I have not read myself, then merely hearing the arguments and trying to find a way out, that will not be laying down the correct law is concerned. So to lay down a correct law is the problem. Now, I was telling you earlier what follows is, in a case titled as Pushpalata, we interpreted for the first time amended section 6 of Hindu Succession Act is concerned. It took a lot of time. Good lawyers assisted us. Late G.S. Vishweshwara, Vijay Shankar, number of lawyers, senior advocates. We invited them to come and assist us. They assisted us. We rendered a good judgment. That was taken up before the Supreme Court. It was tagged to some other matter which was pending from the Delhi High Court is concerned. Then in between, Supreme Court itself took 3 inconsistent views. That led to the matter being referred to a larger bench. Now, because of the inconsistent views, a lot of other cases got generated in the trial courts. Some saying the parents must be alive on the date the amended provision came into the statute book. As far as a woman is concerned, or a female co-partner is concerned, her entitlement would be with reference to what was the question? Whether it is with reference to 1956 Act as it was originally brought in, whether the amendment would be retrospective in nature. Even if it is retrospective, what are the other qualifications? Other things generated it, and Supreme Court contributed for the delay. Supreme Court contributed for multiplicity of litigation by taking inconsistent views, because 3 of its judgments did not go hand in hand. And that's the reason why a larger bench was constituted. And for the larger bench to decide, tell you, it took about 2 years. Had the larger bench decided the matter at least 2 years in advance, immediately when the bench was constituted, a lot of litigation could have been arrested. Litigation is nothing but cancer. One can bear cancer, but not litigation. I have been a practitioner, I have been a judge, and I have also seen my father as a litigant, how he suffered. And this kind of a thing, unless it is nipped in the bud, it serves no purpose. So these appeals no doubt give succor, but the appeals, what the problem would be, would end up in ultimately law delays. A trial court may take 5 years to decide a matter. But if the appellate court again takes another 5 years, what is the fun? And suppose it leads to a second appeal. Suppose it again takes the route of a special leave petition and a civil appeal before the Supreme Court. At least, not only one generation, there will be 2 generations facing the same litigation. That should be avoided. Appeal should be the minimum. Appeals in a way educate the bar as well as the bench. Not only training the judges, our judgments, see, many a times it may not be necessary for us to report certain mark judgments for reporting, but we mark for reporting. The reason is it should be readily available to the trial judges are concerned, because they may not be getting assistance from the bar. Many of them will be lacking. See, in the present day world, we are getting this digital library. Earlier, even library was not there for the trial judges. Very inadequate facilities. Less said about it. Many of them used to even travel by BTS bus or the local transport is concerned. Their service conditions very horrible. They were not provided with the minimum required infrastructure is concerned to decide the matters also. Some of the courts you must have seen how shabby they will be. Even the seating arrangements will be so bad and other things. Government has not, successive governments have not cared to provide the required infrastructure is concerned for the courts to function properly. All these things add up for the committing of errors by the judges are concerned. Not not an error which is committed intentionally. No judge, according to me, would commit an intentional error unless he has not lived up to his oath. Every judge takes the oath, and that should be his Bible or Gita or Quran, as the case may be. The oath is nothing but the father and mother to you. You have to remember the oath which you have taken, and you have to go by that oath till you are discharging the judicial functions are concerned. Once you are out of it, you practice it. See, otherwise you can even resign, go out and you practice it. There's a lot of money in profession. I tell you, the judge gets not even 1% of what the member of the bar earns. What I earn as a practitioner now after my retirement, that even one appearance of me is more than 1 month's salary in the High Court. Just one appearance in the Supreme Court takes care of me. If suppose I have 3 or 4 appearances in a day, I have seen my friends in the Supreme Court having 8 to 10 appearances also, and their stakes are much high. Let us not. But thing is, you should be contented. Once you are contented, see, everybody, we can't see, an agriculturist cannot compare with an industrial labor. An industrial labor cannot compare himself with a management representative. So also, a rural practitioner cannot compare himself with a district practitioner is concerned, or a district practitioner comparing with the state level practitioner. Everybody has their own way of life. But at the same time, contentment leads to happiness everywhere. Now, instead of that, the judges commit mistakes means where, that's why I was telling you, the judge, if he has gone by his oath, normally he doesn't commit mistakes. If he has committed a mistake, bypassing the oath means that is something wrong. The judicial obstinacy is what we saw earlier, or something else. But such elements are less in the field. What my personal experience is, I don't say there is no black sheep. There may be black sheep, but the percentage is still in single digit only, I can say, which is not the case vis-a-vis the other institutions are concerned. But all human beings, we do not know whatever. But the percentage of such category is certainly in single digit only. That is a happy situation. And there are checks and balances. Because of these appeals and divisions, we know who is going wrong where, why he has gone wrong, and whether there are methods to checkmate him or eliminate him also. Appeals and divisions give us a handle to know what the person is doing. We have administrative judges for every district. Similarly, when on the judicial side, every judge would be watching what kind of orders are being passed by the other judges are concerned. Similarly, for a single judge in the High Court, the matters are taken up in appeal. The appellate bench can know what is going wrong. Suppose the appellate bench is going wrong, Supreme Court definitely, when taking up the matters under 136, would be, see, that is how the system itself will be disciplined by way of this appeals and revisions are concerned. Appeals are vis-a-vis revisions are a better remedy. Revision is very, very, very narrow, whereas an appeal is concerned, it is quite wide open. Everything is available for reconsideration, both facts and law. Whereas revision is concerned, it is limited to questions of law, pure questions of law. So these are the aspects on which you will have to ponder over. There is a lot to say. I do not know whether I am bypassing now itself. I have bypassed about half an hour's time. When he said, when Vivek said, sir, appeals, I said it is quite a vast subject. I say I will not be able to do anything. Touch and go. I said, all right, when you have chosen it, I'll go by whatever you decide. So if I get an opportunity to address on any particular subject at length, I would be happy because I'll be doing justice. I would prefer to put forth my views on any particular view in an expanded manner so that the students would be able to take something out of it. If I keep touching and going away, then it serves really no purpose. So I'm sorry I have taken half an hour more than what is required. Because 10:30 to 11:30 was my lecture. Now it is already 12:04.
No, sir. Sir, if time permits, could I ask you a few questions which has been from the students?
Yeah. Everybody now is free to ask questions. That is how it should be.
So the first question is, with respect to
Sir,
appellate power. Sorry, sir.
Pardon? Yes, Vivek, proceed.
Yeah. Sir, you are gone. With interruption, you can have some water too.
No issue.
In fact, you really, I really feel you did justify and tell us how powerful is the tool of appeal in rendering justice. Sir. So nice.
No. Appeals are the need of the hour, I tell you. In the system in which we are living, the environment in which we are living, if there are no appeals, you can take it for granted that the system will collapse.
My God.
There has to be checks and balances in every system. Appeals, according to me, is the best checkmate to judge each and every person who is presiding over the courts.
This is a good angle, sir. This is a good angle.
It is a requirement, and if suppose somebody cannot appeal because of lack of resources and something has gone wrong, I tell you, injustice is perpetuated. That should not happen. See, so it's just decided, just extended the hand of the divinity is concerned. Your functions are nothing but divine. You are instead of somebody appealing to the mercy of God, he is appealing to you. And you should live up to that.
Right.
When you are discharging divine functions, you should be clear from everything, and you should not decide when you are not in a fit frame of mind. Instead of deciding it today, you decide it tomorrow. Nothing is going to happen. That means you have applied yourself on deciding. And even if it is tomorrow, if the same error is being committed, then you can take it that the person has some prejudice or bias. He suffers from something. That means that can be got corrected only in an appeal. And in appeal also, unfortunately, there are some litigants who suffer everywhere throughout. They started at a bad moment, and the suit is instituted in a wrong time that goes on endlessly. Personally I have seen a good case being not appreciated throughout also. And we say, bad luck upon Hindu, na ಏನು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. ನಾ ಮಾಡೋ ಕೆಲಸ ಮಾಡಿದ್ದೀನಿ, ಆದರೆ ಅವ್ರು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ತಿದ್ರು, ನಾನೇನು ಮಾಡೋಕ್ಕಾಗತ್ತೆ. ನಾವೇನಿದ್ರು ನೀರಿಗೆ ಕುದುರೆನ ಹೊಯ್ಬೋದೇ ಹೊರತು, ಹೊಂಡಕ್ಕೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೋದೇ ಹೊರತು ನೀರು ಕುಡ್ಸೋಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಬಂದಿರೋದು ನಾವು ಹೇಳಿದ್ದೀವಿ, ಅದ್ರ ಮೇಲೆ ಅವ್ರ ಇಷ್ಟನಪ್ಪ. That's why appeals is the need of the hour. Appeals have to be entertained. If there is a point involved, first appeal as a matter of right should be. See, I had a policy. Some of us, we have our own set of norms. When a matter concerning immovable property comes before the court, normally we tend to spend more time, because that will be the lifeline of the family. If it is a miscellaneous right, say for example, an election matter, we don't spend much time, because once we are clear that there is nothing, simply take decision. But as far as a property dispute is concerned, we do spend our time, because it not only affects the person who is before you, but the entire family. Why family? Even the next generation also may suffer, because if only somebody has only a piece of land, and even if that is taken away, then what remains? They are on the street. If they are on the street, they are a liability to society. So if society suffers on account of such people, then what values we have? So this is how, when rights to property is concerned, the courts do spend some extra time is concerned while taking decisions. And while considering such matters also, if something has gone wrong, that means somewhere something is wrong, definitely wrong. And some people, despite all appeals and divisions, if he is not fortunate enough, suffer throughout also. That is very, very less. But however, there are cases. There are cases. It's not as if it's... See, I tell you how law delays. My father had instituted a suit in a family partition. There was some unequal distribution, it appears, when I was just about 4 or 5 years old. And he was given some monetary equivalent for which what is called as a bond was written on a plain paper. That was not honored subsequently, and he had to go to a court. He had to travel about 36 kilometers one way. It was we are from a remote village. So that made him to learn so much. He said, I'll make my son a lawyer, what may come. I was the first son in the family, what may come, yes, I'll make him a lawyer. I was interested to become a lecturer, rather, professor. I was a science student. I wanted to get into botany, but I got a seat in zoology. It was BZC at that point of time. Then my father said, I want you to become a lawyer. You are thinking of becoming a master, I say. Who needs you? That's how life changed. You know, that thing is, one should know where injustice has happened. Even though law may not enable you to give certain relief, but still you can navigate in such a way where at least some injustice is erased. It's possible for a judge. If a judge has thought over the process and he has felt that his hands are tied because the position of law is otherwise, but still injustice is there, something has to be done. See to it that parties go to mediation, conciliation, sit across the parties, see to it what best can be done. Something can be, injustice can be addressed. It's a divine function. One should have that opportunity. I would appeal to all the students that they spend some time in the bar, become good lawyers, then become good judges also. Don't go to corporate world, remain in litigation. Lawyers are meant, your law education is meant not for corporate sector. Society spends on you. The law education, what you are getting, is not out of what the fee, meager fee, what you pay for the institution. It's no way. Society spends for you. Means society means the state infrastructure is made use of to make you lawyers. Make you lawyers for what? To serve the society, not to go to a corporate world. And those who get into corporate world, after some time they say, I did a mistake. I should have remained in litigation. Yes. Litigation is not paying, certainly, in the initial stages. But once it opens up, then you do not have enough space to keep your money. That will be the money you will be earning, if at all you wanted to earn. If you really wanted to serve, then get into the judiciary. You will have a lot of satisfaction. Or become lecturers in the institution. Keep molding the children. That is definitely a far more attractive job. Our job satisfaction could be far more compared to even a judge. A faculty member definitely will have far more satisfaction than either being on the bench or being on the bar. Remain in litigation. That's what I will appeal. Be available to the society. The courts will take care of all your needs. If you are a regular practitioner, the courts will take care of all of you. See, I am the first generation lawyer in the family. I came from a remote rural village, but still, if I have reached this position, because I remain committed to my work, nothing else. Nothing else. I did not have any godfathers nor godmothers. Whatever opportunities came my way, I made use of. That's all. So like that, the first generation students in the law schools are concerned, don't worry. There are a lot of ways and means. To come up with this. If you are committed to your work, there is plenty of work available. Plenty of work. There is no other profession which can fetch you so much money. See, I'll tell you, in Supreme Court, there are about 100 lawyers, you can say, whose income may not be, on an average, less than about 50 to 100 crores a year. Every Friday, Monday and Friday is spinning day for them. It's just like the race course. And whatever, at least 8 to 10 appearances some lawyers have got. Maybe the figures are mind-boggling. Let us not go into that aspect. The thing is, everybody has handful of work, provided he is committed to do work. If you want to remain in profession, if you also want to get into something else, then you are neither here nor there. You have to be satisfied somewhere or the other. That gives you a lot of work to do and a lot of service to render to the society. Yes, Vivek.
Yes, sir. So, sir, the first question is with respect to appeals in a wide manner. So the students are asking, because there has been a lot of tribunalization, civil court's power has been reduced. Now, for example, the setting up of MCLATs, company law tribunals, etc. Now the question to you is, they're asking is with respect to what is the further role for tribunals in the case of appeals vis-a-vis our civil courts?
See, civil courts, if the let us take for example NCLAT, NCAT first. Now, the statute itself provides for an appeal. Now, whatever civil court used to decide, certain matters are being taken out of the civil court's jurisdiction under the special statutes, and there the forums are created. Now, for example, these debt recovery tribunals are concerned. They are all civil matters only, recovery of money, nothing else. But if it is beyond 10 lakhs, the recovery by a bank is beyond 10 lakhs, it has to necessarily go to the debt recovery tribunal. Now, against the order of the debt recovery tribunal, an appeal is provided to debt recovery appellate tribunal is concerned. Once that is over, still the remedy is not taken away. And it is always available. Any order which become final, other than the one decided on the civil side is concerned by a civil court, you can avail writ remedy. Against all orders of the tribunals, writ remedy is available to you. So it is no way taking away any work from any court. An alternate forum is created. ADRs has become the order of the day because of the huge pendency in the courts. Now, proportionately, there is no increase in the courts are concerned. Proportionately, there is no increase in the infrastructure of the courts are concerned. I'll give you an example. This Negotiable Instrument Act was amended. Check bounce cases, which were earlier only civil matters, were also made criminal matters also. Now, they can be prosecuted. Those who commit the default, they can be prosecuted. Now, it has opened up a Pandora box. The filings are so much. The courts are unable to manage. There is no proportionate increase. See, as and when a new statute is brought into effect, then the required infrastructure as far as the adjudication of disputes arising of that statute are not being created by the legislatures, or the executive doesn't take care of it. To the existing system itself, everything is being thrust. Now, the courts are unable to even cope up with the work which they have now at hand. Now, day in and day out, the legislatures make new laws. And out of that, a lot of disputes get generated. And they are being brought before the court. Now, if the existing infrastructure, existing litigation itself is not being able to be handled. Now, if this also generates, then there will be delay. That's the reason a very special statute will now has led to a forum being created in the form of a tribunal or a quasi-judicial authority. Against that, normally an appeal is being provided. Against those two orders, the writ remedy is always available. So it doesn't affect the civil court jurisdiction is concerned. Civil courts have enough work. Civil courts are unable to even cope up with the existing demand itself. Whatever is being provided in the form of tribunals, everywhere an appellate tribunal is being provided with. If not a tribunal, if not an appeal, at least a revision is provided to either a district court or to the high court. Somewhere or the other, the matter comes into the court again from the tribunal. Yes.
So the second question is with respect to first appeal. Now the students are asking, to what extent can production of evidence and appreciation of evidence be done in first appeal? Will it almost happen like a trial only?
Order 41 Rule 27 is the one which you will have to look into it. Now, when it can be gone into, when it cannot be gone into, you will find a beautiful judgment under the title Union of India versus Ibrahim Uddin. It is reported in 2012, 8 SCC 148. Union of India versus Ibrahim Uddin, 2012, 8 SCC, page 148. More particularly, whereas '63 onwards, you will find the entire case law, previous case law having been looked into. Unless one satisfies the requirement therein, that is 27A, B, C is there. You just see what this provision says. I'll just give me a second. There are mandates which does not permit it. See, 27A is concerned. 27 is with regard to production of additional evidence in appellate court. That the parties to an appeal shall not be entitled. It starts with the word not be entitled to produce. Okay. Shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. So that is completely blocking. But what it says is, but if A, the court from whose decree the appeal is preferred, has refused to admit the evidence, which may be a rare case, then next is the party seeking to produce the evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after exercise of due diligence, be produced by him at the time when the decree appealed against was. So unavailability, due diligence, all these factors are brought in there. Then the last one is if it is required for the court itself to decide, that is C. B, clause B. The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce the judgment or for any other substantial cause. So if the court itself feels that there is dearth of evidence, and instead of sending the matter back by way of a remand to the trial court, by receiving some additional evidence, if the matter can be given a quietus here itself, in that event, satisfaction being recorded, the court can call upon the parties to make available the additional evidence is concerned. To enable the appellate court to pronounce the judgment on all aspects of the matter, if evidence is required, it can suo moto do it. Or if the party is able to establish that despite due diligence, he could not produce it, it was unavailable at the time when the decree by the trial court was pronounced, then only. Otherwise, it is impossible. That's why the provision starts with shall not be entitled to produce. So on this aspect, there are plethora of case law. You can go through it. But however, this Union of India versus Ibrahimuddin, according to me, is a very important judgment wherein almost all the entire case law has been taken into consideration and the ratio of law laid down on this aspect.
Also, the next question is with respect to the special leave petitions which you are speaking about. So some students have asked that also, so I'll put it here. Their question is, isn't Indian Supreme Court's appreciation of so many special leave petition a burden? Like considering so many SLPs are filed in our Supreme Courts and they're accepted, why should there be a scope for special leave petition in civil matters? Is it necessary?
If everything is good, would you have thought anybody would spend so much money and go to Supreme Court? See, I went for the first time to Delhi somewhere in 1986 or so. At that time itself, even getting inside the court halls was a tough task on these miscellaneous days are concerned. Entering inside a court hall, because they are normally close the doors. They don't keep it open like what we do here. Supreme Court, everything is centrally air conditioned. Either they need heaters or they need air condition. One of the two. Otherwise, in Delhi, you can't survive. Though there is plenty of money for lawyers, but life is very bad. If somebody wants life, he has to remain outside Delhi. If somebody wants money, he can go and make money for somebody else, not for himself. That is the truth of it. My son, who is a practitioner here, when I was on the bench, I thought he should be away from Bangalore. That's why I told him, if you have the inclination to go to Delhi, I'll send you there itself. I say, you go and practice there. Then we sent him soon after his enrollment here. 1 year he was there with Mr. K.K. Venugopal, the present attorney. He had joined his office. Then he said, everything is fine here, but there is no life. If you permit me, I'll come back, but I'll see to it that I don't come to the High Court at all. I'll practice on the trial courts. I'll not even show my face in the High Court. I'll practice there. And so he came back. The thing is, to answer your question, if success, see, if you ask me how many special leave petitions are entertained, ultimately relief granted, you don't get it even in 5% of cases. 95% of the special leave petitions get thrown off. In 5%, you can say notices are issued, matters are entertained, and decisions rendered. There also, it is amazing to see that number of judgments, concurrent judgments rendered by the courts below, including the High Court, are being reversed. That shows what? That there is a need. Everything is not good. If everything was good, then no special leave petition would have been preferred or even allowed ultimately. If special leave petitions are being allowed that means the system is still to gear up. The order of hierarchy is not functioning according to the expected levels are concerned. I tell you, I'll give you another example. In our state, say for example, for SSLC, there will be about 10 lakh students. For PUC, it gets to about 6 lakh students. For degree, it ultimately keeps coming down. Now, as far as filings are concerned, trial court filings on an average in civil courts, we have about a lakh of cases being filed every year on an average. Similarly, on the criminal side also about 1 lakh to 1,50,000 cases are being filed. Now this 1 lakh, see, ultimately when we keep disposing of, we almost maintain the inflow and outflow. How much, whatever is filed, at least if we don't try to allow any increase in the arrears is concerned. We try to at least maintain the balance, if not bring it down. Because filings are more in number, as we have been noticing. The filings are more in number. People are now vigilant enough. They try to exercise their rights and come before the court. That is a welcome step, because awareness in the society is definitely getting increased. So this ultimately, it is the awareness which makes the society to be peaceful. If you are aware of the nuances of the society, definitely you can be happy in living. Now, earlier there was no awareness regarding rights are concerned. That's why people used to suffer. Now people try to assert their rights, come to the court. Now, once the litigant does not get relief in the court, either the first court or the second court, that is the original side and the first appeal is concerned, then second appeal, the success rate is very dismal. You don't find number of second appeals being entertained on the ground it doesn't involve substantial questions of law. Now, I was telling you one judgment of this State Bank of India versus S.N. Goel, decided by His Lordship Justice Ravindran. There, the trial court as well as appellate court had granted the relief to the plaintiff. Second appeal filed by the bank was dismissed by the High Court, saying that there is no substantial question of law. Supreme Court says number of substantial questions of law are there. But unfortunately, the High Court has not looked into it. They have quoted there some very substantial questions formulated in the appeal memorandum on one hand, other hand formulated by the High Court, ultimately saying there is no substantial question. And Supreme Court with pain says that this is how the matter has been dealt with. So all the three courts had concurrently committed wrong. If there is no special leave, you just think of what would have been the position. They ultimately allow the appeal, special leave petition, allow the civil appeal, then dismiss the suit instituted in the trial court, which had been decreed, appeal upheld, second appeal upheld. Three forums had upheld it. So that is how sometimes a line is drawn. Suppose somebody thinks that this is the correct path. The other man does not notice there is another path also. You have to think in different angles. When a matter is brought before you, you should not focus your attention only on a certain way to decide. You have to examine vis-a-vis the other things that are open. If there is application of mind on 360 degrees, then you will rightly arrive at a correct conclusion. You have only examined with 60 degrees or 90 degrees. The other aspect has not been examined. Then it leads to an appeal. In appeal, anything could happen. I'll just tell you how the Supreme Court has felt as far as that judgment is concerned. That is 2008. What the court has said there. This is what the Supreme Court says, para 16. In this case, the failure on the part of the High Court to take note of substantial questions of law involved has led to unwarranted dismissal of second appeal and calls for interference. Trial court had committed wrong. First appellate court had committed wrong. The High Court should have seen that it is a labor dispute. Civil court had no jurisdiction at all. Suit could not have been entertained, nor appeal could not have been dismissed. And second appeal at any cost should have been entertained because it is a question of law. It goes to the jurisdiction of the civil court is concerned to entertain the suit. It was not done. That's the reason. There is a need. Maybe it is quite expensive, not affordable. I certainly feel for it. I feel for the litigant because so much money is being spent, special petitions are filed and thrown off. But I can tell you, one good thing that has happened is digital hearing has saved a lot of money for people as far as Supreme Court is concerned. And the hearings are, according to me, are far more conducive rather than appearing before them and getting the matters thrown off. There is no case. But here, personally, I am feeling that we are being heard. Recently, I appeared before a bench. It was serial number 3. This is Sanjay Kishwan was presiding over the bench. There are two other judges, Justice Anirudh Bose and Ajay Rastogi. They heard for about 1 hour 25 minutes, especially petition. That was serial number 3. They had so many matters to hear. My friends who were below me, they called up afterwards, what is this? I say, you made us to wait for such long period. You are a pain in our neck today. Some of them called up and said, I said, it's okay. But see the intensity with which they hear. I felt really happy. The same thing is happening. Every matter wherever I have appeared, I've been noticing that they hear with patience. They don't have that pressure on them as they sit in the court. See that overcrowded courts, so many lawyers trying to get inside, not able to stand up also. The court halls are small. Unfortunately, the Supreme Court halls are very, very small. Except 2-3 courts, that is first, second, third, or 4 and 5 also to some extent. The rest are all small courts. Even they don't even accommodate about 50 persons. So getting inside, getting outside, you should have a lot of energy. And that way, there is a lot of pressure on the judges there because they will be finding what is this conducive atmosphere is not there for the lawyers to take the seat and comfortably address the arguments. Now here they hear patiently and decide the matters. I feel there is a need for establishing of the benches of Supreme Court in different parts of the country so that people at least from far places like South or Northeast, they are able to avail the remedy that is provided under the Constitution. Now, many of, see, one way I'll just put it to you. Lot of retired judges of the high courts from Kerala and Madras are practicing in the Supreme Court. As far as Karnataka High Court is concerned, except me, there is nobody now currently practicing in the Supreme Court. Earlier, Justice Namohan Das was practicing, he wound up when he came back. Mr. Justice Vishwanath Shetty, who is now the Lokayukta, he was practicing for about 10 years and he came back. See, like that, from our state is concerned, there is absolutely, I can say, no representation. I also stayed there for about a year, wound up my practice, our office is concerned, came back here. Now, thanks God, this digital hearing has enabled me to continue my practice, otherwise I would have given up. Means, the life is difficult, the affordability factor is difficult, you can't survive there with meager resources also. You can't expect, we know the paying conditions of our people here. Not everybody cannot afford to pay like corporates in the Supreme Court. The paying capacity of people in South is comparatively less. Maybe urban people, they don't mind. For them, they have money plants and they get money. But for others, it is not so. Rural people and all, it is, say, persons who used to refer matters to from Gulbarga, Dharwad is concerned. For them, even paying 20,000, 30,000 is a big difficult job. Filing expenses will be about ₹1 lakh. So that's why there is a need that more benches are required to be established. At least 3-4 benches in the country, other than the principal bench, are required so that the system will strengthen up. We try to find fault with the trial judges or the first appellate judges, that is district level judiciary is concerned. Same thing should be done for the high courts also. One should not hesitate to get corrected. And correction can take place only when there is an appeal or a revision. Nothing beyond that. And that also, many times, lack of assistance must have led to an erroneous decision being arrived at. It is not as if it is deliberate. Lack of assistance. Lawyers might not have assisted, or the judge must not have applied himself also sometimes. And that error should not be allowed to remain uncorrected. Yes.
Yes, sir. Over to you, Atulya. Thank you, sir. Atulya.
Thank you, sir, for your valuable insights on the topic and also sharing with us your personal experience as a member of the bench. Now we have almost come to the end of the session. Before that, a notice to the participants, please fill in the feedback form provided in the chat box. And lastly, to conclude the session, I'd request Mahabalish
One second.
to give the vote of
I'm sorry. I could not take you deep into the subject is concerned for want of time.
No,
No
sir.
problem, sir. This is what we wanted.
Exactly.
If I had gone by what is contained in the statute book, then I would not have even covered a part of it. It requires much more time. Much more time. I only shared my experience.
Yes, so that's a fresh perspective that we would have missed out generally. So over to you, Mahabalish, for the vote of thanks.
The best and the beautiful thing in the world cannot be seen or even touched. They must be felt by heart. Thank you is a one such prayer among them. I consider it a great privilege to propose a vote of thanks on behalf of our Kaylee Society's Law College Venugopal. I thank our guest speaker, Honourable Mr. Justice A.N. Venugopal Gowda, former Judge, High Court of Karnataka, for gracing us with his thought-provoking address. We are really enlightened with your knowledge and presence. Thank you so much, sir. Hearty thanks to our leader, our beloved principal, Dr. J. Mallikarjunaya, for his enthusiastic, constant support. I extend thanks to the Internal Quality Assurance Cell Coordinator, Dr. Manoj Kumar Hiraman, and special thanks to faculty's Assistant Professor, Mr. Vivek Narayan, Assistant Professor, Mr. Prasad Hiraman, for guiding us. Last but not the least, I thank all the students, viewers, for the successful participation in this wonderful session. Thank you, sir.
Thank you all.
Thank you, sir. Thank you. Thanks a lot, sir.
Thank you. Take care.
Sir, I'll come and meet you. Thank you, sir.